Have you ever wondered how a huge corporation, something like a Reliance or a Tata, goes from just an idea in someone's head to a legal person that can actually own property, sign contracts, and even go to court? It's a pretty fascinating legal journey, and it's packed with critical steps, some really important duties, and honestly, a little bit of legal magic. So in this explainer, we are going to unpack that entire process, step by step, from a simple idea all the way to a fully formed company. So, here's our roadmap for this journey. We're going to start with the main character of our story, the promoter, who is really the company's architect. Then we'll dive into the sacred duties they have, and these are serious. After that, we'll tackle the tricky puzzle of contracts signed before the company even exists. Then, we'll walk through the actual step-by-step blueprint for incorporation, and finally, we'll witness that magic moment when paper turns into a person, legally speaking, and see what that really means.
All right, so let's kick things off with our central figure, the promoter. Now, this isn't just some fancy title. This is the person, the visionary, who dreams up the business idea and then does all the heavy lifting to bring that company into existence. They really are, in every single sense, the company's architect. Okay, so what does the law actually say? Well, if we look at Section 2, subsection 69 of the Companies Act 2013, it gives us a pretty specific definition. A promoter is someone who's named in the prospectus, or someone who has control over the company's affairs, or, and this is key, someone whose advice the board of directors is used to acting on. Now, the really interesting thing here is that it's all about influence and control, not just a job title. The law is also careful to exclude people who are just acting professionally, like the lawyer who's only there to draft the documents. At the end of the day, it's more term of business than a strict term of law, and it covers all the work that goes into getting a company off the ground.
So what does a promoter actually do? I mean, look at this to-do list. It's massive. They are the ultimate project manager. They're the ones who come up with the whole business idea. They go out and find the very first people to subscribe to the company's shares. They get the foundational legal documents drafted. We're talking the memorandum and articles of association, which we'll get to in a bit. They have to appoint the first directors, secure bankers and brokers, negotiate all those initial contracts, and figure out how the heck to raise the capital. They literally do everything to get the company up and running. But here's the thing. All that power, all that influence, it doesn't go unchecked. It comes with some very, very serious legal responsibilities. The law knows that promoters are in a unique position of trust, and it puts on them what you could honestly call sacred duties to the company they're trying to create. Now, this right here is an absolutely crucial distinction, especially if you're studying corporate law for an exam. A promoter is technically not an agent. Why? Because the company, the principal, doesn't even exist yet, and they're not a trustee because, well, the trust hasn't been formed. But, and this is the key, the courts have said they are in what's called a fiduciary position towards the company. This means they owe it the highest duty of good faith and loyalty, and they are totally accountable for any money they might secretly get.
So what does this fiduciary duty really boil down to? It's basically two core principles. First, no secret profits. This doesn't mean a promoter can't profit at all, but it absolutely means that profit cannot be a secret. Any money they make from deals with the company they're forming has to be out in the open. And second, full disclosure. If they have any kind of personal interest in a transaction, like say they're selling their own land to the new company, they have to disclose that interest completely, no hiding things.
In this classic case, Gluckstein v. Barnes illustrates the no secret profits rule perfectly. So you had a group of promoters who bought some property. They resold it to their new company and disclosed that they were making a $40,000 profit. Okay, fair enough. But what they didn't mention was an extra $20,000 profit they'd made on the side by buying up the property's debt for cheap. The House of Lords said, nope, they held that the promoters were in a fiduciary relationship and had to disclose all of the profit. The huge takeaway here is that the disclosure has to be complete, and it has to be made either to an independent board of directors or to every single initial shareholder. Partial disclosure is no disclosure at all.
This brings us to another classic legal puzzle, a real head-scratcher that every promoter has to deal with. What on earth happens to contracts that a promoter signs on behalf of a company before that company is even legally incorporated? I mean, can a non-existent thing be a party to a contract? For a long, long time, this created a huge headache for businesses.
This timeline shows you just how much the law has evolved. Before 1963, the rule in India, following famous English cases like Kellner v. Baxter, was super rigid. The contract was simply void. The company was a non-entity, so it couldn't be bound. It also couldn't ratify or approve the contract later because you can't approve something on behalf of a principal that didn't exist at the time. You can imagine how impractical this was. Promoters couldn't lock down an office lease or supply agreements, creating a huge hurdle. So thankfully, the Specific Relief Act of 1963 completely changed the game. Now, a company, after it's incorporated, can choose to adopt and enforce these preliminary contracts as long as the contract was for the company's purpose and fits within its objectives.
But here's the catch, and it's a big one for the promoter. Even with the Specific Relief Act, that personal risk doesn't just disappear. Until the brand new company formally adopts that contract, the promoter who signed it is personally on the hook. If the company decides, nah, we don't want this deal, or if the whole venture just falls apart, the other party can sue the promoter directly for damages. That liability rests squarely on their shoulders.
So our promoter has navigated the duties and the contract risks. Now it's time for the main event, following the official blueprint to register the company and finally bring it to life. This is the real nuts and bolts of forming a company.
We can break down what might seem like a really complex legal process into these 4 key steps. First, you've got to reserve a unique name for the company. Second, you draft the foundational documents that are going to govern everything. Third, you file the application and all the paperwork with the Registrar of Companies. And finally, if everything is in order, you get the official certificate of incorporation.
This slide gives you a look at the core paperwork that basically forms the company's legal DNA. First up, you have the Memorandum of Association, or MOA. Think of this as the company's constitution. It tells the whole world what the company is all about, its objectives, its capital, and so on. Then you have the Articles of Association, or AOA. This is the company's internal rulebook, laying out things like the powers of the directors and how meetings work. You'll also need declarations, consent forms, an address, and a statutory declaration from a professional saying, yep, all the rules have been followed. And nowadays, a lot of this is simplified and can be done online through an integrated form called Spice Plus. Okay, this is it, the final and most transformative stage. All the planning, all the contracts, all that paperwork, it has all been leading to this one single moment, the birth of a brand new legal entity. Once the Registrar of Companies is satisfied that everything is in order, they issue this, the Certificate of Incorporation. And let me tell you, this is so much more than just a piece of paper. This is the company's official birth certificate. The date printed on this certificate, that is the day the company legally comes into existence. And this is where the magic of that certificate kicks in. Under Section 9 of the Companies Act, the moment of incorporation changes everything. The company becomes a distinct legal person, totally separate from its owners and members. This is the foundation of the corporate veil. It has perpetual succession, which is a fancy way of saying it can keep existing even if all its original members pass away. It can own property, sign contracts, and crucially, it can sue and be sued, all in its own name. It's not just an idea anymore. It is a full-fledged entity in the eyes of the law.
So, the company exists. It's a legal person. It has a corporate identity number. But here's a final little twist in the story. Just because it's been born doesn't mean it can immediately start doing business or borrowing money. Nope. There is one last, crucial hurdle to clear.
And that final step is the Declaration of Commencement of Business under Section 10A of the Act. Within 180 days of being incorporated, a director has to file this form, INC 20A. And this form confirms 2 really important things. 1, that the people who promised to buy the first shares had actually paid for them, and 2, that the company's registered office is a real, verified place. It's basically one last check to make sure the company is genuine and has some money behind it before it starts operating. If you don't file it, you're looking at penalties and maybe even getting the company's name struck off the register. So, with that final declaration filed, our founder's journey is officially complete. It really makes you think, what does this final check tell us about what corporate regulators are most concerned with today? That's a good question to ponder.